Well, hello everyone, and welcome to the European Deforestation Regulation Simplifications webinar. My name is Arne Mielken, and I'm delighted that we get to spend this time together to talk about the latest changes and the latest updates on the EUDR. The EUDR has been a hot topic over the last years and is about to come into force. And if you think today, as we're recording this mid-May, the EUDR implementation, the go live is far off, it is not. Because in today's world, we need to get our processes and procedures ready for a 1 Jan, in essence, a 2 Jan implementation date. Officially 30th of December, but hey, what's going to happen on these 2 days? So I am Arne. There you see a beautiful picture of me. Okay. And here you can see a little bit more about my background so that you know who's speaking to you. I had the pleasure of working in customs and global trade for 20 plus years. And it's been a wild ride, lots of changes, lots of modernization. Customs and global trade is always evolving, is always modernizing, is always changing, is responding to different needs. And I have the privilege and the honor of following this development, not only for the European Union, but also for the United Kingdom and the United States. As you see in my background, it is all about international. So when it hits borders, when it goes across borders, I'm interested. So that's why EUDR is right up my street, because the European Deforestation Regulation deals with borders a lot. Now, I want to quickly introduce the company that I work for, and this is Customs Manager Limited. Customs Manager Limited is a company that has a wide range of clients who we work with and who we serve. We can summarize all of this as a diverse ecosystem of cross-industry companies of all sizes and shapes, spanning global logistics, consumer retail, heavy industrial tech, and international trade compliance, all unified by a shared operational focus to make customs and global trade as efficient and effective and compliant as possible. We serve all across different sectors and sizes, whether it be logistics and supply chain, industrial tech and manufacturing, consumer goods and retail, finance and advisory. We help where there's a need for help. I'm also proud that we have a lot of great collaborations that we work with. So these are industry insights that we get from these associations that we incorporate in our work. This also allows us to talk to the peers, talk to the decision makers, talk to those that have opinions. And as you can see, we're not only limited to customs with the Customs Practitioners Group in the UK. We're also established, we'll also work closely with the French ODAS group. We also work a lot with the German association, so we're part of the German-British Chamber of Commerce. We work with the European Forum of Foreign Trade. We're part of the Außenwirtschaftsrunde, and everything in relation to German-British relationship. And why is that? It's because we are operating out of the United Kingdom, and we have a large client base in Germany that needs to get support when dealing with the United Kingdom. And of course, if you want to connect on our socials, then here are the socials to connect with. It's a website, LinkedIn, obviously. There's my personal LinkedIn, and there's Customs Manager LinkedIn, and you're good to go. And of course, if you want to see something about EUDR for free on YouTube, then we got a wide range of videos on EUDR that gives you a good introduction. If, for example, you need to share what is EUDR with your colleagues and they just you don't have the time, well, then you just share one of these videos, and then people can look at this in 5 minutes and understand what EUDR is all about. Saves you time, and is just helpful and available on this YouTube channel. If you want to work with us, we offer 4 different solution services if you want: bespoke customs and consultancy and advisory, event training, obviously in company, online and on demand, actionable trade intelligence, which offers a 30-day free trial on customsmanager.info. Go there, check that out. And if you need customs clearance, UK and US, then just get in touch and we'll help you. All can be discussed in a 1-hour free call, which you can book as decided here. Right. Last thing to note before we go, and that is that we offer EUDR training, as you would expect. So if you want the whole explanation of what EUDR is and how it works and what's changing, and more details about what we're discussing here today, because we only have 1 hour, then it is on customersmanager.org/events. And this is the EU law compliant training, allows you to learn how to apply the EU Deforestation Regulation of import and export operations and trade within the EU. And it gives you a lot of professional examples, ideas, opportunities to discuss. You get a certificate of participation. And even if you're collecting CPD points, then it's worth 3 CPD points. So I encourage you to check out our training and join us for the next session. Now, before we get into the updates that just happened, here is a reminder of what this was about. So what was EUDR? Right, is the regulation ensuring that 7 commodity codes, or 7 commodities, 7 goods, for raw agricultural goods like cattle, wood, cocoa, soy, palm bean, coffee, and rubber, solid or in exported form, do not cause global deforestation when they come to the EU or leave the EU. And for this, a strict proof is required. Somebody has to have the evidence that there was no global deforestation. So operators and traders, we will discuss what these are. So in a nutshell, any business importing, exporting, or even selling goods within the EU must legally prove that their products do not come from recently deforested or degraded land. The key deadlines, you may know them, large and medium enterprises and some timber businesses must comply by 30 September 2026. And largely for the purposes of easement, really, that's what we go with. Now, I know some have 6 months more, small and micro businesses, but quite honestly, what's 6 months going to do? Not that much. If you're not ready by the 30th of December, there's not much more we can do in 6 months. So let's just assume 30th of December 2026, which is not long to go. So we all have to get ready. If we're not ready and we're hearing this for the first time, then please get in touch because we got to get going. And already we are seeing a trend of supply chain transparency improvement. And what we're seeing is a drive to track and trace every part of the supply chain. And we've not only seen this in areas such as CBAM or CSDDD or even Russia sanctions, if you want, but this idea of due diligence and transparency, track and tracing, we see this in food. We see this in fish trade, in beef trade, where we scan the product's label or a little QR code and we can track and trace all the way back to the farm where the animal was raised or where the fish was farmed. And that is the track and trace we need for veterinary matters. But now we need that same track and trace for other legislations. As I told you, CBAM for CO2 emissions, but also sanctions to exclude Russia from the supply chain. And lately, of course, in the US for the calculation of aluminum and steel products, derivatives, for duty calculation. So this track and trace system where you go back to the origin is not new, but it is really, really clear in the case of EUDR. So we are seeing the ability to track and trace and prove every step a product took from the farm to the shop. And it is that what we are installing, not only for EUDR, but for many other legislation. And it's the direction of travel. So the more you can improve that and the more you can insist upon it and the more you can enforce this with a contract, the better it is. And of course, this will then lead to quite interesting discussions about, well, if you can't prove where something's from, then maybe we ought to discontinue it. Now, I'm sourcing it from there. Now, I know this is easier said than done, being me here in an office, but if you can't show that this is deforestation free, then you really don't have an option because you're not allowed to get it into the country, into the union, or even into markets. So it's not really your choice whether you want to trade with this product or not. If you can't track and trace, or as they say here, track and prove it, then it's off. It's off the menu. It's off the table. It's gone. So this is all fine in principle. However, the execution of this, how do you track and prove, is more difficult than maybe envisioned. If you see this from a purely environmental perspective, and as noble as the objectives are, the challenge remains that there is no protection of the forests if you overburden businesses to the extent that they will go out of business because of bureaucracy and red tape. So we need to find a formula that works with businesses that import, that allows them to continue to import, that allows them to make choices towards eco-friendly and forest-protected products, whilst at the same time keeping their operations afloat, keeping their operations going. And so what happened was we may have, gently put, overshot a little bit here with our objectives. So as noble as the ideas were, there is and was and probably still is an urgent need to simplify. So the EU Commission, having realized that, it published its official simplification review of the EUDR. And don't forget, you can get these slides on the blog at customsmanager.info. And this is where these links are live. So you just click on them and then you can just access the document. So that was rolled out, the simplification review, as well as a major package of rules, fresh guidance, and tools to prepare industry for the upcoming law. And it's supposed to be slashing red tape. We hear words of a cut down of paperwork, estimated reduction of compliance costs down by 75%. Well, that would be amazing, wouldn't it? If we had nothing more to do, or very little, or something, let's say we had only manageable things to do, that would be good, wouldn't it? So updating the product list, the Commission proposed changes to the product scope, what is actually covered by the law. So that's important, because if we understand which products are in scope and are not in scope, and that list changes, we need to understand what the changes are likely to be. And also there are some changes to the IT systems. Okay, so there are some items that will be added and some items that will be removed from that list. And that is crucial. Okay, so let us go through all of these documents that were published. As I've said, there is the simplification review that was published, and that says to the European Parliament and the European Council that efforts have been undertaken to simplify the EUDR, and we're told this has led to a 75% burden reduction. So in addition, we now have an updated FAQ document, so we're going to look at that. We're going to have an updated guidance document. We're going to look at that. An enhanced information system. That's not yet decided. There is a draft that we haven't seen. So it's not been published. At least I haven't seen it. But it's supposed to be an enhanced information system that features a simplified declaration form specifically designed to ease the burden on micro and small operators. And that is a kind of new category of operators that didn't exist before. So that's interesting. But in order to understand this, and we'll look at this more closely, we'll have to remember what we're talking about here, which party we're talking about. So here we're talking about a micro and small operator. Just remember, this is an operator simplification. So these are the things we'll be talking about: the report, the FAQ, the guidance, and the product changes. So the simplification report, we already talked about it. There is a 75% of administrative burden reduction. We have trade facilitation tools, okay? And they include repositories of producing countries' legislation and commodity certification schemes. So what does that mean? Why does that matter? Because if you are an operator and not a small and micro operator, then you have due diligence obligations. But that requires you to scan national legislation for compliance. And to find these national legislations, Brazilian tax code, Indonesian forest management law, one more, Burundi Rights of Indigenous People report. How would you even find that? How would you even read that? Well, with AI, but still, how would you know this is an accurate source? How would you know it is up to date? How do you know it's the latest version? You can spend hours trying to figure out what the law of the land is, but that's part of your due diligence requirements if you are an operator and you're operating from basically any country. You need to rely on certain sources, and these sources need to be correct. So the EU is putting together a list of the documents, and that helps because if you relate to that, if you use that document that the EU publishes, then you can assume that that's been okayed by the EU. And then I would find it odd if you would be penalized for using a report the EU recommends you to use. So that's good. Trade facilitation, we'll go with that. Supply chain impacts, okay. Structural changes are being seen, is what the report says. And it drives sustainable production. So there seems to be good impact. We're getting a greater transparency across supply chain, and the sustainable and competitive production practices in sustainability worldwide are enhanced. So from that point of view, it goes in the right direction. So that's what the report says. And again, you're free to read it and make up your own mind. I want to focus more on the guidance documents and the FAQ. Okay. So what do we got? So we got an updated document that directly addresses the most common stakeholder questions. So in other words, people have asked the Commission questions, and instead of making a law about it, they have put it all into guidance. Now, guidance and FAQs are not law. They're not legal. They are an interpretation. They do not replace the law. They are therefore answering questions for which there may not be a legal basis. That's not ideal because you are relying on unofficial guidance to shape your understanding of the law. But that's the best we have. So we have to do with what we've got. So we have a documented documents such as guidance and FAQs that is supposed to give answers to the most common questions, making clear the guidance on downstream supply chain obligations and simplified regime for micro and small primary operators. So we are introducing a new simplified regime for micro and primary small operators, and that's going to be detailed in the new version. Concrete explanations are provided for complex technical and operational issues, especially focusing on e-commerce and geolocation modalities. One of the big issues is, how do I send a small pack of coffee? What do I need? Do I fall under EUDR if I send a small pack of coffee? How can I even comply? And also the other question is, do I need to buy expensive software in order to get the geolocation data of my farm? And the answer is no. And in the training, I'll be explaining and why not. So don't think the solution of geolocation is found in expensive software you have to buy. It is not. There is a great infographic I'm going to show you in a moment that I would really think is your must read, and I'll share that with you. The EU has published it. For me, it's really great. Moreover, there will be parts on harmonized enforcement materials that have been extensively reviewed and discussed in member states to ensure that the law is enforced consistently and uniformly across the entire EU. The EU FAQ, 95 pages now, 10 topics, 117 questions and sub-questions, all answered. So if your question's not answered, I'd be surprised. You must be in a very special niche. 6 questions have been totally deleted, leaving 111 active questions. The 10 topics you will find in the FAQs are traceability, scope, subjects of obligation. So what are your obligations? Definitions, super important. due diligence. So if you're, if you're tracked by due diligence, what are you going to do? Benchmarking, partnerships, digital implementation, so the EUDR information system, timelines, other questions, and penalties. So there's a lot there. Obviously, we can't go through all of them right now, but I want to just point some out to you. So I'll give you some of the examples. Okay, so here, for example, you will see what we answer in part 2, scope. Okay, so you can see here how this has been organized. And you can see that just in part 2, there are 14 questions. And it's really important questions because it answers the questions, is my product in scope of EUDR or not? Because if it's not, I can go back to sleep, or I can disregard the FAQs. So this is all very important stuff. Of course, we're going to cover that in our training, but the answers are already here. I'll give you an example of added FAQ. So something that's new in this FAQ. So you'll see that the EUDR applies to all economic operators involved in the supply chain of relevant commodities and products listed in Annex A of the regulation. But now it is clarified that we have 3 main actors: operators upstream, operators downstream, and traders. And if you can tell me the difference between the 3, then you understood EUDR. And in the second part, if you can explain to me what you are you an operator? Are you an upstream, an operator downstream, or a trader? If you can tell me the answer to these questions, well, then you understand EUDR. So good news, if you don't understand it, well, now the FAQs explain it to you, or you join my training. Then I'll give you another idea of what else you can find, okay, that wasn't there before. So more detail about what are the obligations of downstream operators and traders. What about downstream operators and traders? What is the difference with upstream operators? What about the obligations that downstream operators and traders have versus upstream traders? So all of the things I've just said, you can clearly see in the guidance now, and it's really worthwhile reading because it is part and parcel of what you need to do. So if you understand that, you know what your obligations are. Don't understand where you fall within this or get it wrong, you'll do work that you don't need to do, or you'll fail to do work that you need to do. So FAQs one thing, guidance next. So in guidance, we have 37 pages and 11 topics. So here we complement the FAQs by a more structured guidance. And we have 11 topics such as definitions of placing on the market, making available on the market, and export. These 3 concepts are absolutely essential, right? They have to do with whether you're an upstream operator, a downstream operator, or a trader, but they are absolutely essential to understand. Again, don't understand those, can't do compliance obligations. Definition of operator, downstream operator, micro and small primary operator, and trader. So note that we have a little bit of a difference here. So if I go back to this, I talk about upstream operators. So the FAQ talks about upstream operators. Here in the guidance document, we're now only mentioning operators, okay? But what we mean is upstream operators, because there we distinguish between upstream and downstream operators. We also have the traders, so the 1, 2, 3. And what you see here now, which also is in the FAQ, to be fair, is the introduction of a 4th category of operator. No, a third category of operator, or a 4th category overall. So we had upstream operators, downstream operators, and traders, and now we're having upstream operators, downstream operators, micro and small primary operators, or MSPOs, and traders. Okay, so that distinction is now newly added to the guidance. 3 is the date of effect and the time frame for application. 4 is due diligence. Again, if you are an upstream operator, that is where you have to be. Clarification of complexity of the supply chain, legality, product scope, regular maintenance of a due diligence system, composite products, the role of certifications, and third-party verification schemes, and agricultural use. Now, if you're more of a visual person, you may be interested in the EUDR supply chain infographics. It's been released in the 4th edition, and it helps you to understanding your position in beef, cocoa, coffee, palm oil, rubber, soy, and wood supply chains. And it's really, really a cool guide because with visual aid, it explains the EU deforestation rules for beef, cocoa, coffee, palm oil, rubber, soy, and wood. It explains to you when you are a first-time importers or the producer, and when you need to adhere to strict due diligence requirements and submit a due diligence statement. Now, if none of what I'm saying makes any sense to you, then you know what you've got to do. You've got to join the training, right? Because we will explain all of this in detail at the training. You've seen the link. Downstream relief, subsequent traders and operators do not report or repeat due diligence, as they only pass it along and log the existing DDS numbers. Okay, so that's very, very crucial. And here we have the distinction between upstream and downstream again. And here you can see in reading 2 and 3, who needs to do what, who needs to do something upstream and who needs to do what downstream. Okay, and upstream's harder than downstream. So don't be upstream, be downstream. And of course, now we have more simplifications, micro and small primary operators, as I mentioned, MSPOs, in low-risk regions can use simplified declarations instead of standard due diligence. So all of that can be found in the visual guidance. To give you an example of how that looks, here is the infographic. And again, you can download that with the link provided in this presentation. And you can see here that we have, we have a whole list. It tells you what you need to do. It tells you 2 ticks for full due diligence, 1 tick for reduced due diligence, or no need to any due diligence. So, wherever you are in the supply chain, here's what you need to do. Okay. So that's why this is pretty cool. So we talked about the simplification report. We talked about the FAQ. We talked about the updated guidance. And now we're going to talk about law, because I told you there was a delegated act proposal. And I told you there was a implementing act proposal, but that implementing act proposal we haven't seen to the time of this recording. We have seen the delegated act proposal. Now I'll tell you, this one will pass. Slightly modified, maybe, but probably it'll pass. I assume it'll pass in some shape or form. Okay. Now, why does this matter? Is because it amends the commodities list in Annex 1. So commodities and their derived products are subject to EUDR and come with a whole list of obligations and requirements and process and procedures and all that. But if you're not importing, placing on the market, or exporting EUDR products, then you're not concerned by EUDR and the whole thing goes away. So what you want above everything else is not to be in Annex 1. You don't want your goods to be in Annex 1, because then you're off the hook with EUDR. But if you're caught, you got to go. You got to do it. You got to figure it all out. Okay? So if that list changes, we need to know about it. So here's what they are proposing, which is likely to happen. The first thing we do with this new proposal is we provide a clearer definition of the core commodities in Annex 1. And we do this by adding specific botanical and biological definitions to clarify exactly which species are covered. So here for cattle, for example, the genus. Anyone in classification knows we deal with genus, we deal with subgenera. Also, if you are in CITES regulation, I'm a CITES trainer, so endangered species, we deal with the scientific names of animals and plants all the time. So this is nothing new to us, but it might be a bit strange to you, but it's completely normal. It's the nomenclature the taxonomy of scientific names of animals and plants, fauna, and flora. We then add some exemptions. Yay! Two new product categories are likely to be completely exempted from the regulation, and they are neglectable samples, low value, small quantity product samples used solely to solicit commercial orders, and B, testing and research products. Products imported or used strictly for scientific examinations, technical analysis, or industrial or commercial research, provided they are destroyed during testing or returned to comply with legal obligations. Now, I give you that. That doesn't help a lot, but for some, it helps greatly. And then comes the big one, and that are the changes to the product coverage. There are 4 areas where these changes will be made. Some will be removed, some will be excluded, some will be added. Part 1 concerns cattle and cocoa. Well, there are some removals, raw hides, skins, hides, etc. Okay. And then there is frozen cattle tongue. Yoo-hoo, that gets included. Well, we can live with that. Extract, essences, and concentrates of coffee are now added to the regulations. Coffee growers won't be happy. Palm oil sees a lot of changes. The list expands heavily into specific palm oil chemical derivatives and downstream products. So here we are going for detail, and whether they're synthesized or not. So that brings us to the point where you need a technician to understand if you're actually importing this, which is just interesting because when we had only the commodity code, a customs person could just deal with it. Either you had this commodity code in your SAP or in your ERP system, or you didn't. Now you may have the commodity code, but we're not really interested in the whole commodity code, only a section. So you might have to go to a technician to figure out whether it's actually what type of glycerol it actually is. And then for wood, paper, and rubber, and you can see here there's a lot happening here. Mainly exclusions. Now exclusions are good, and you can see what's being excluded. So that can generally help because most products relating to to waste paper, packaging, free marketing materials, etc., and an exclusion for used goods. So that's important because once it's already been used, it's already been in free circulation. So when it's secondhand apparel, then it shouldn't be subject to EUDR. As I said, there's a implementing act on the way, and it is supposed to do all these things, and that is mainly to improve operability, to have a dedicated contingency plan if the system's unavailable. There is a grouping feature that is supposed to improve usability, and of course the big one is a simplified declaration form for micro and small primary operators designed to align with the existing due diligence standard format, just simpler, right, for the small operators. Okay, so that is already the main gist of what was published and what the simplifications bring. I'm just going to wrap this session up with a few tips and tricks that I have for you, which I hope you'll appreciate. And then we can launch the discussion. Now, I should warn you that the discussion amongst us is only available for those that join live. So if you're watching this on demand, I'm sorry you missed out on it. So please join for the live sessions so you can join us for the discussions and the exchange of views. So here are a few EUDR tips and tricks that I would recommend you look at. Okay, and you could call this, if you want to be a little cheeky, how to get around EUDR. Okay, you can call it tips and tricks, but what I'm really saying is let's see if we can get you off EUDR. Okay, legally, of course, all legally. Okay, So, and I'm not talking about specific industries here, right? So there might be specific rules for specific industries. But in general speaking, the first thing you want to do if you want to get off the EUDR, and I'm not talking about, avoid, I'm not in Annex 1. So if you're not in Annex 1, then the whole thing stops. So that would be the best. I've already explained that. But assuming you are in Annex 1 and you do import or trade or export EUDR goods. So that's the baseline. So the first thing you want to do if that happens, you have an EUDR product coming in to the European Union, and now what? Okay, the first solution to get around EUDR is be an SME. Yeah, so the classification you see here, okay, if that's you, and we're talking about solely the size of the specific legal entity, explicitly excluding parent group or subsidiary thresholds. Now, for some of you on this call, this is really important. Determined solely on the size of the specific legal entity, explicitly excluding parent group of subsidiary thresholds. Okay, if that is so, and you're excluding your parent company, then you've got to meet two of the three listed here. 25 million balance sheet total, 50 million net turnover, or 250 employees. If you're below that, two of those at least, you're an SME. That's good. If you're an SME, good for you. Less for you to do. Okay. Next. The next thing I recommend you look at is whether you are a DO or a T. You want to be a DO or a T. What? Well, DO is downstream operator. Okay. Because if a commodity, a regulated EUDR commodity is already in the EU market and you are the operator, you're transforming it, you're changing it, then you just must manage and verify the upstream DDS statement, the reference number, or pass it on to the next one in the chain. That's much easier than having to do the whole shebang if you're an upstream operator. We'll talk about that later. Okay, so the first thing you want to do if you're not an SME, if you want to be the first thing you want to do, you want to be an SME. Then if you have a choice, you want to be either a DO or a T. Okay, a DO has less to do than a UO, an upstream operator, if you follow. And ideally, you will be a T because a trader just distributes and therefore passes on the existing upstream DDS reference numbers to ensure traceability, but doesn't have to do DDS, the due diligence, okay? DD, due diligence, and doesn't probably have to self-generate a DDS. So be an SME, be a DO or a T, okay? Now, if you can't, okay, if you can't be an SME, and if you can't be a DO or a T, then you are in trouble, okay? Because then we have this to do. We have an operator. You might then be an operator, okay? What if I can't get around it? Then you are a company or an individual that places a regulated commodity onto the market or export it from the EU for the very first time. Okay, so you place it on the market for the first time or you export it. That's how it should say. Okay, then you have the primary responsibility. You bear the core burden of the regulation. You must conduct exhaustive due diligence to guarantee that the products are completely deforestation free and legally produced. You need to be filing a declaration. It's called a due diligence statement. Okay, before commercializing the goods, you are legally required to access the EU system and file a comprehensive due diligence statement, which must include precise geolocation coordinates of the harvest plots or whatever plots of land concern your product. And then this, however, is you're only an operator if you're the initial market entrant. Okay, so you're not then a downstream operator. Okay, you're not a trader. You cannot be a upstream and downstream operator. You can either be an upstream or downstream operator, and you can be an upstream operator and a trader. If that confuses you, then get onto the training. But now there's a new category of operator. So there is a little way to get out of jail. You are an operator. So I hope you're an MSPO, a subcategory of operator with simplified reporting obligation. So I've told you, if you are an operator, you're in trouble. Okay. So the only way to get you out of that trouble is to be an MSPO. So now you must be a natural person or qualify as a micro or small undertaking under the financial and operational threshold of the EU Accounting Directive. We've just discussed what an SME is. Okay. So let's look at that again and see what the definition of micro and small undertaking is. The next criteria, so you must qualify as a micro and small undertaking. The next criteria, you must only get your products from a low risk location. I'll explain that in a moment. The EU has designated countries as low risk for deforestation. The best example I can give is Saudi Arabia. Why is Saudi Arabia a low risk country? Because it's largely desert. There's not a lot of forest there. So no risk of deforestation. I simplify, but that's the point, right? Please don't scream if you're from Saudi Arabia and there's a lot of forest in your country. I'm just trying to make a point. Direct market access, you must directly place the covered products onto the EU market or export them directly out of the EU, excluding producers who use intermediates outside the EU. So you can't go this one to this one to this one to this one, from you to the EU or out. And then you must be the only producer. You must be the primary producer who personally grows, harvested, raised, or obtains the products in your own plot of lands or establishment within the country of establishment. So this is all to help the people that really, really need it. Okay. So this is not a get out of jail for everyone, but for those that genuinely would be overwhelmed by the work that needs to be done and they can't manage, they can be an MSPO, and that can make it easier. Now, if you're not an MSPO, then you are still an operator. Well, then you're still in trouble. But I might get you out of jail and into house arrest. Okay, so you're not in jail because you're an operator and you're in big trouble. But you're still halfway in jail. You're on a house arrest. Okay, so you're an operator. The only thing I can recommend to you is that you trade with low-risk countries only. So the EU categorizes producing countries into one of three distinct tiers: low standard and high risk, based on historical deforestation trends, agricultural land expansion, and natural forest governance. There are 140 designated low-risk countries. And if you're a low-risk country, then the burden on the operator is lower. Still, basic product information must be collected, but you're exempted from performing full risk analysis and you have mitigating factors. So if that is you, we need to talk about how we're going to organize this. Then standard and risk, right? You source from standard risk nations such as Brazil and Indonesia, or high-risk nations such as Russia or Belarus, and that triggers a strict legal requirement to conduct exhaustive due diligence, including risk mitigation and geolocation tracking. And also, the more risky, the more monitoring, the more inspection. So minimum annual compliance audits from 1% for low risk to 3%, and then even higher for high-risk countries. 9%. So that's 1/10 of all your shipments being inspected. Now, if that doesn't work, then I cannot help you anymore. You are then in extended due diligence. Now, if you are an operator, then this is what you need to do. There are 3 pillars, and they are information and geolocation collection. Okay. And again, we need more time to talk about what all of that means and how this is organized. And again, I'm telling you, you can do this without buying expensive software. And I know this because I am a former trainee of the European Commission who worked in satellite navigation in the European Commission with Galileo satellite navigation. So I know about Copernicus satellite navigation and the wonders that this does. So no need to buy software. The EU's got you. Pillar 2, risk assessment. Yeah, then this is hard. Okay, this requires staff and knowledgeable staff. So this is what I do regularly in my work. I do the risk assessment for the companies to get ready for EUDR. Okay, so we then have to go through the entire supply chain and we have to compare it with all the markers and all the areas that we need to cover under EUDR. That can take a while, but it's a really good exercise and it helps transparency. So it's not in vain. It's not just for this. It's also to help you clean up your supply chain if needed. And then you will identify risks and then you need to mitigate them. Okay, so there's everything from having a neglectable risk to actively mitigating risk that you encounter in phase 2. That might lead to third-party audits, shifting sourcing countries away from high-risk produce entirely, a conversation about what are we going to do with this. Okay, so all of which will leave you in a better position than you are. This exercise only needs to be done once and then maintained. This is also an ongoing compliance issue, obviously, but there are ways that you can integrate that into an existing due diligence system. I'm happy to discuss it with you. You know, you have a free call if you want it. And then the final step of the whole thing is the submission of a due diligence statement, and that you will do through Traces. There is a centralized system called the Information Management System, and this is where your formal due diligence statement goes. Wow, I think I have spoken quite a lot. And so now is the time that I pass to your questions and where we draw this to a close. But we will do this offline. So I will stop the recording. So we're saying bye-bye to our online viewers. And just to let you know that if you want to get in touch, here are the details. Here's the email address. Here is the number. I'm available to help you. I obviously am excited, as you can see, to teach you about it, to tell you more about it, and I'd be happy to support you. So thank you for watching, and I'll say goodbye to our online viewers, and then we are off to the discussion with our live audience, which is great. So thanks once again, and let me close this. Thank you.